And welcome you all to this meeting. Ryan Whittle.
Good morning, Lord Carloway. Good morning, Mr. Flynn. In relation to any changes to the current system of recusal, whereby it is for a judge to decide whether or not to recuse, you comment on the inefficient disposal of business in the courts. I'd like to explore the balance between the efficient disposal of business and having systems in place that ensure there is trust in judicial decisions. In that respect, could I ask whether there is any way of quantifying the risks to efficient disposal of business, and if so, whether your office has carried out an assessment of this?
In relation to, are you talking about the process of declining jurisdiction or recusal, as it's put, the processes that we use?
Yes.
Well, could I start with a little preface and state that, so far as my own concerns exist in relation to this topic, my concern is primarily not that judges are not recusing themselves in particular situations, because I'm quite satisfied that they do when they should do. My concern, and this is also to do with the disruption of business, is with judges or sheriffs who are recusing themselves unnecessarily in circumstances in which they should not do so. And that is a much more common phenomenon. In other words, one has to bear in mind, again, we have litigants who will effectively try and forum shop. That is to say, they will encounter a judge or a sheriff who is not to their liking, and they will attempt to remove that judge from the proceedings on pretexts such as having some remote connection with the case or the people involved in it. And that type of thing can cause major problems in the management of business. The way these things done in the normal case, where perhaps somebody is represented by a member of the legal profession, is that if there is a genuine concern that the judge or sheriff does have an interest in the case, that will be raised informally with the clerk of court, and in practical terms the sheriff or judge will simply decide not to be involved in that particular case. Again, that is not something which can be done in every court, and in particular courts which only have one sheriff, and especially if it's not raised in advance. What happens again in the sense of practicalities and reality is that civil business, which is again what we're talking about here primarily, I think, can be allocated relatively late in the day, and a sheriff or a judge may only, on the day in question, be faced with an application formally in court to decline jurisdiction in that case. If he does so, then it is likely that that case will simply have to go off, with all the inconvenience that involves. Now, I'm not sure if you wanted me to deal with there was a specific point about whether we think judges should not deal with this question but pass it to another judge. Which would you wish me to deal with that point?
If you would, please.
Again, the answer to that particular problem is this: if a judge does not recuse himself in circumstances in which he should have, then any litigant who is dissatisfied with that and loses the case can appeal that, and the matter will be reviewed by 3 judges. So there is a form of open public scrutiny of a decision not to recuse a judge. If there was a system whereby that judge could not decide that matter himself or herself, and after all it is he or she who knows whether he or she has got a direct connection with the litigation or the persons involved in it, if that person had to pass the matter on to another judge or sheriff, you would cease the business in that case for the particular period of time until that matter was decided. You would also cease the business which is scheduled for the other sheriff or judge in order that that other judge could take the decision. That other judge is likely to find the decision very difficult if he or she doesn't know the particular facts. So I hope I'm, in a realistic sense, explaining the disruption to business that these decisions can involve. And the simplest way to deal with them is the way we are dealing with them at the moment. is that, first of all, there is the informal route, which would mean that the judge or sheriff is not hearing the case in the first place. But if that judge decides that he or she should hear the case in any event and is faced with a formal motion to recuse himself, that matter is dealt with in open court, transparently, and is subject to the appeal process.